Hi, I'm Ken Lammers, and welcome to this week's video podcast, or Lawcast is, I think, probably an appropriate term. Today's topic is going to be a case that came out last week, or actually on the 30th of August, from the Court of Appeals of Virginia. The case's name is Luganbill against Commonwealth, and it's a case which deals with, well, rather cleverly deals with getting around Crawford against Washington and its requirement that someone must be in court to testify in order for evidence to be allowed in. Basically getting around the confrontation clause of the Sixth Amendment. I don't agree with the outcome of the opinion, although some of it is dead on, but I don't agree with the outcome. However, I think it is a well thought out and, well, as I said, clever opinion. I think it's something that needs to be thought about and read by others. So, I'm going to go over it here today. First of all, let's go over some of the very basic history of the Sixth Amendment. The Sixth Amendment of itself is, and you can look through any number of cases and find all sorts of history as to how in England there were statutes that allowed testimony to come in without the person being there to testify, but how this was seen as an exception to the rule that you had to have somebody there to cross-examine. But when our Constitution was put in place, it's pretty clear that it was their understanding that the common law required someone to be in court to testify against you if they had evidence against you. So here's what was written into the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to be confronted by the witnesses against him. That seems pretty clear. I mean, it seems pretty straightforward. If there's a witness, you got a right to have him in court to say his bit against you. Well, over the years, the problem comes from the fact that, well, you've got a bunch of lawyers and a bunch of judges determining how this will turn out, and they mucked it up a bit. The major problem being hearsay. They're developed over the years, particularly, and I believe the case's name is Roberts. I don't know how to cite for y'all, but this case allowed hearsay in if there was indicia of reliability. Well, of course, what happens when you start asking about indicia of reliability, the indicators become all sorts of things, and there becomes very amorphous tests with 8 or 9 or 10 different elements, considering the totality of the circumstances, all the sorts of things which basically guarantee that pretty much anything is going to make it in, except for your most blatant hearsays. And that was the law for a while, and that's what the problem is. Then came Crawford against Washington in 2004, and that's what I'm going to discuss in the next section here. Makes it to the Supreme Court, Federal Supreme Court. And Justice Scalia, speaking for 7 members of the court, says, no, there's got to be a confrontation. Now, it actually comes to the court as a hearsay question, but he walks away from that and says, whether the hearsay is covered or not by this, there has to be confrontation. And if there's no confrontation, then there has to have been a prior hearing or deposition or something wherein the defendant had the ability to confront, whether he did or not, but had the ability to confront, and there has to be the unavailability of the witness. So that's where the test is now. If it's somebody who could be confronted in court, then they have to be unavailable, and there has to have been a prior hearing wherein the defendant could have cross-examined them. However, As we all know, the Supreme Court wouldn't be the Supreme Court unless it threw a bunch of dicta in, which really wasn't relevant to the case. So I'm going to go over a few things which it put in, which left wiggle room for the state courts and the lower circuit courts. Okay, so Crawford's out there, but it left about 2 to 3 paragraphs which lower courts could work with to get around Crawford. First of all, is some sort of, Scalia says there's some hearsay which may not be necessary to confront, and there's some which is necessary to confront. I'm not sure how he gets that, because almost any occasion of hearsay would be something you would want to talk to the witness about. How did you hear it? What was the person doing when he said it? Etc., etc. But here's what he says in a single paragraph. The focus also suggests that not all hearsay implicates the Sixth Amendment's core concerns. An offhand, overheard remark might be unreliable evidence and thus a good candidate for exclusion under the hearsay rules, but it bears little resemblance to the civil law abuses the Confrontation Clause targeted. On the other hand, ex parte examinations might sometimes be admissible under the modern hearsay rules, but the framers certainly would not have condoned them. I gotta take some issue with that, and I'm pretty doggone sure that if somebody's called to the stand and says, or if there's a statement, I heard Bob say Joe robbed the bank, that's something that you pretty much want to confront about. Whether it's the guy who heard Bob say Joe robbed the bank, whether it's Bob, or whether it's, you want to confront everybody down that line to see if there's anything there which is untruthful, biased, or an out lie. You want to confront everybody there, and I'm not sure what Scalia thinks he's getting to there, but he does lay it out, and he goes on further. There's more in here about. There's one point where he's talking about how the authorities, law reviews, etc., have said that they should abandon having the Sixth Amendment apply to anything outside of testimony. First, they suggest that we apply the Confrontation Clause only to testimonial statements, leaving the remainder to regulation by hearsay law. And he goes on, skipping into the next paragraph. In White, we considered the first proposal and rejected it. Although our analysis in this case cast doubt on that holding, we need not definitively resolve whether it survives our decision today, because the case at hand is clearly testimonial. There's no doubt about that. And then towards the end of the opinion, he says again, where non-testimonial hearsay is at issue, it is wholly consistent with the framers' design to afford the states flexibility in their development of hearsay law, as does Roberts, and would an approach that exempted such statements from Confrontation Clause scrutiny altogether. I'm not sure, well, part of the difficulty here, of course, is that Scalia doesn't say what he means when he's talking about testimonial, non-testimonial hearsay. And that's about clear as mud, that one statement which I read to you at the beginning about how some things could just be regulated by hearsay and some things must be regulated by the Confrontation Clause. And so some hearsay is inside the Confrontation Clause and some hearsay is outside the Confrontation Clause. Like I say, it's about clear as mud. But it gives the lower court some place to work. And they, believe me, they work it. So next what we've got is the Court of Appeals in Virginia and Luganville against the Commonwealth. and that's a 30 August 2005 decision. And it does basically an analysis of the actual reading of the breath test on the machine as to whether it's hearsay and whether it's testimonial. And it does an analysis of whether the officer's report of the numbers on the machine and the conditions is hearsay and whether or not that is testimonial. Now, first of all, we're going to go over from the machine. It says that the court says that the reading, the numbers, whatever, the readout from the machine is not hearsay because it's not someone testifying about what somebody else said. It's an indicator of a chemical reaction. I suppose that with an extreme definition of hearsay, you could say, yes, this is hearsay because the readout isn't actually, it's an observation of the actions of something else. However, I think the court's probably got it right here. You know, this is not hearsay. I mean, it's just a machine that's going to react one way or another, and therefore, when it reacts, it is indicative of the presence of whatever it's looking for. It may not be accurate, but it's indicative. And then it goes through whether or not it's hearsay or not, whether or not it's testimonial or not. And it says, no, this is not testimonial. It is just what appears on the machine is just indicative of what the machine has found. And therefore, it is the same as handing over the murder weapon or introducing the murder weapon into court. It's not something which is going to change at a cross-examination. And I think that's the most relevant part of this test. Is it testimonial? Yes or no? The reading from the machine isn't testimonial, and I think the reason it's not testimonial is because it's something that there's no way it's going to change under cross-examination. And therefore, it falls outside of Crawford because it's not testimony. And I think the court's got that right. Although I don't think the court had to do the hearsay analysis. I think it got it right on the testimony part, and it's good to go. So next the court turns to whether or not the operator of the certificate sworn out or put together by the operator of the machine, that the machine is working properly and that these are the results, whether or not that is subject to Crawford analysis. Because it's not even debated in this case whether or not the officer was present, he wasn't, or whether he was unavailable. Apparently he could have been brought in, and it wasn't, there was no prior opportunity to interrogate him or to cross-examine him. So what we end up with then is a two-part analysis again. Again, the Court of Appeals does the is it hearsay or isn't it hearsay analysis, which again I still think is irrelevant, but they do it. And they say, well, they don't really even do an analysis. They fold. Yes, of course this is hearsay. Then they move on to the second part of the test, which is the actual Crawford examination. Is it testimonial? And their decision, and this is where we go over the rainbow, folks, is that it's not testimonial. Because it's not about prior testimony at a preliminary hearing, before a grand jury, or at a formal trial, and it's not a statement obtained during a police interrogation. And it doesn't accuse Luganville of any wrongdoing. Okay. Oh, and by the way, in a footnote, it blows right past White, which was the case which the Supreme Court talked a little bit about. It says, the White opinion wasn't adopted by the court in Crawford. Let me see where it is. Because the Supreme Court did not expressly adopt any of the formulations or use them in its analysis, we decline to rely upon them here. So that's what it says about White. And if you go back and you look at White again, what White said, or what the court said in its opinion was, we were asked to limit this to merely testimonial statements, I should say. We were asked to limit this to merely testimonial statements. In White, we considered the first proposal and rejected it. So what they say is that in White, we rejected holding this simply to testimonial statements, and we think that may be doubtful now, but we're not going to overrule it explicitly. So they didn't. So technically, that's still law of the land. At least by their reading, that's law of the land. The Virginia court blows right past that. It says they didn't adopt White, therefore we don't have to adopt White. One of the things that's indicative of the weakness of this position, as it is in almost any court case, any court decision, you can tell something's usually fairly weak by the appeal to authority. And this case gives us, after it says it's not testimonial, let's see, about a page of authority citing this, that, the other case. Not a whole lot of reasoning, but a whole lot of appeal to authority. In the end, the Court of Appeals basically finds that it's not testimonial by defining testimony as something which is done in court at a previous preliminary hearing. Well, actually, let me read the exact words. Testimony would be something at a preliminary hearing for a grand jury or at a former trial, or a statement obtained from a witness during police interrogation. Okay, that's an extremely narrow definition of testimony. That's far narrower than any definition of testimony I've ever seen before. It would not include things where a witness came to court and had not previously been interviewed by the officer or the prosecutor. It would not include things, which happens a lot of times in misdemeanor events, that an officer will subpoena someone, or a citizen complaint will be taken out, someone will be subpoenaed, and they won't have been interviewed previously by someone. But I mean, it's an extremely limited definition of testimony. I'm going to read from Webster's what the definition of testimony is in here, or testimonial is in here. And testimonial, mind you, is not, I'm going to skip over the parts which are talking about religion and stuff like that. Everybody who's from the South knows what a testimonial is. Okay? But I'm going to read, the sections which have to do with law. Testimonial. 1. Something that serves as evidence, proof, testimony. 2. A certified statement, affidavit, or warrant. Testimonial evidence, by that definition, is wider, far wider, than what the Court of Appeals is providing. I think as well, while my personal definition of testimony, as I've said before, would be something that could possibly change in court. So, introducing the firearm into evidence isn't testimony, because the firearm's the firearm. How it was used and all that, that definitely can fall into the testimony range. The firearm's the firearm. Introducing the test itself for blood alcohol content here is not testimony, because it's just saying that the machine indicated the presence of alcohol. No matter what you do, Nothing's going to change that. That machine at that time indicated the presence of alcohol, and therefore it's not testimonial because it's not going to change. However, the police officer who certified that machine read this, and that that machine was run properly, and the room is the proper temperature, and the conditions were properly done. He may change his testimony when he comes to court. It's the entire purpose of the confrontation. As well, something may come out in his testimony which he didn't even realize would cause problems with the machine. Say he didn't realize that you're not allowed to operate radio transmitters within a certain distance of these machines, or the temperature has to be kept at a certain level, or as said before, kidded about, what I was told at one CLE recently, well, probably within the last year, that if you drink Diet Dr. Pepper before you get tested on one of these breath machines, it'll indicate the presence of alcohol, which an officer might not very well realize. He may not have held them long enough, the 20 or 30 or whatever minute waiting period before doing the test. All these are things which the defense is very much going to want to cross-examine this man about. And all of these things would be testimony. They would be testimony as to the proper operation of the equipment. They would be testimony as to the proper reading of the equipment. It's all testimony. The court moves on, though. It's not just that narrow reading of what testimony isn't all that the court goes for. It says then, that around all that authority I was talking about before, the appeal to authority, it says the second prong of this is that it's not really what this is meant to apply to. It says the statements do not accuse the defendant of any wrongdoing. These are the police officer statements. They don't accuse the defendant of any wrongdoing. Rather, the statements are neutral in character, relating only to the operation of the machine and the qualifications of the officer administering the test. Well, no. They're not neutral in character. They are accusatory in character. He is accusing this person of having failed the breath test on that machine, which means that he is presumed guilty in Virginia of driving under the influence. He is stating, and he's not neutral in any way, shape, or form. He is one part of the adversarial process. And he's stating that he's qualified to run this machine, which, since we don't have since we're not allowed to talk to him, we can't question him about, confront him about. He's stating that, again, the conditions were perfect, which we can't cross-examine him about if he's not in court. And he's stating that the result this machine gave is one which causes a presumption of guilt in Virginia. These are all statements that are, and at the very least, the last one is an accusatory statement. The others are statements which need to be cross-examined for veracity as to whether or not it was the proper conditions. He was trained properly. It's testimony. I mean, it's pretty much impossible to get around it being testimony. Now, I know a number of courts have. I saw the resort to authority that the Court of Appeals here used too, and all sorts of courts have gotten around it. It's just like Scalia pointed out earlier in Crawford, when he talks about how all these courts got around the Sixth Amendment with the hearsay exception. Well, now they're getting around the Sixth Amendment with the play within what testimony is. And the weird thing is, well, I'll get back to that in a second. But here's a couple of statements from Crawford itself. Written evidence is almost useless. It must be frequently taken ex parte and very seldom leads to the proper discovery of truth. Well, obviously, that's pretty much about an interview, but it's the same sort of thing. It's written evidence. It's not very useful, or not as useful as actually confronting someone. Here's the point that I think is more, this is more on point. Leaving the regulation of out-of-court statements to the law of evidence would render the Confrontation Clause powerless to prevent even the most flagrant inquisitorial practices. Raleigh was, after all, perfectly free to confront those who read Cobham's confession in court. Well, with this sort of thing, with the blood alcohol content, there's nobody to cross-examine who turned it into the court, because it'll be sent directly to the court's file, and the prosecutor will move it into evidence. Your Honor, I move the blood alcohol content into evidence, blah blah blah, and you can't cross-examine the prosecutor. So there's not even, you can't even cross-examine whoever's introducing it into evidence. So it'd be even more bulletproof than the confession, or than the accusation in Raleigh's case. And the truly strange thing about this is that it's not that hard to get a local police officer into court for a DUI case. We're not talking about somebody who has to be flown in from the other side of the state. It's not the instance where there's a drug test where there's a centralized testing agency in Richmond, and if you're in Wise County, that person must come all the way out to Wise County to testify. That's not the way it is. For blood alcohol testing, officers, deputies, troopers are trained to do it on site in the county where it occurs. So, or city, I should say, county or city where it occurs. So therefore, he may have to come 15 minutes if he's on duty. He may have to sacrifice half a day because he's going to testify on two or three cases. This isn't as difficult enough to raise this kind of situation, and I'm not sure why there's such a problem here. Well, this is where my analysis ends today. Let me give the eternal caveat. This is not legal advice, and it is not legal authority. My research for this, pretty much in its entirety, consisted of reading Crawford and reading Luganville. I've not read the background cases, so one of these cases out there that I'm scorning as an appeal to authority could be an amazingly well-researched and well-reasoned case which would totally blow everything I've said out of the water. I doubt it, but it's possible. If you're interested in this, I strongly suggest you go read the two cases. I think it's a very interesting read, and I'll be very interested to see whether or not this goes en banc in the Court of Appeals, or an appeal to the Supreme Court of Virginia, or maybe even higher, because it is an interesting issue. Ladies and gentlemen, with that, I'm going to bid you adieu, because it is 1 o'clock on Sunday, and I'm going to go watch the NFL. Y'all have a good week now.